Welcome to Gimbal's Tip of the Week. Too many lawyers lose money because they create too narrow a definition of what they think they should be paid for. Let's say you need to create an estimate or a budget for a complicated matter with lots of contingencies and variables. It may take several hours of reviewing the facts and circumstances before you're able to come up with a reasonable estimate for the real work. And that's the problem, distinguishing between the effort it takes to make a preliminary assessment and the so-called real work. This week's tip: if you frame your preliminary assessments in a way that deliver value to your clients, and that value is obvious to your clients, then you absolutely should be charging for them. Hi, I'm Karen Dunn Skinner. I'm a lawyer and a Lean Six Sigma black belt. I'm also the Global Advisor on Legal Process Improvement to the International Institute of Legal Project Management. I help lawyers and others in the legal profession build more profitable and productive practices. Today's tip comes out of a coaching session Aileen Leventon provided to our Practice Accelerator membership, but it is so good that we wanted to share it with you. Imagine you're asked to estimate the cost of a complex litigation matter. Estimating the fees or coming up with a budget may require a detailed evaluation of the case itself, including its merits, the possibility of settlement before trial, and the likelihood of success at trial. Your client's reasons for litigating will impact their perception of the value and therefore their willingness to pay for certain kinds of activities. You'll want to determine their level of commitment to winning the case. Does the outcome of the legal work have a high value to them personally or to their business? How hard are they willing to fight? Is this a high-stakes bet the farm matter? How toxic is the relationship between the parties? Is there any hope of settling? How vested is the other side? Is this just a matter of money, or is someone's integrity being called into question and their reputation put at risk? I know from experience that the legal spend sometimes becomes a secondary consideration when someone's professional reputation is at stake. Pyrrhic or not, the focus can become vindication at all or any cost. Whether you charge for the time, energy, and effort involved in your preliminary assessment depends very much on how you frame that assessment and characterize its value to your client. You may not be drafting statements of claim, interviewing witnesses, or preparing your arguments. But if your preliminary assessment helps define your strategy for the litigation, then frame your assessment in that light. If you take a phase-based approach to the matter, the preliminary assessment might be phase 1, and it can be done on a fixed fee or an hourly basis. The bottom line is this: don't start from the perspective that the real work doesn't begin until you've fixed the estimate with your client and that you can't charge them for that assessment. Instead, evaluate the value of that preliminary assessment to the client. If it delivers value and you frame it in a way that makes that value clear, you will be able to bill your client for the preliminary assessment. And that's it for this week. I've put a link to the Practice Accelerator membership down below. If you found Aileen's tip useful, check out the membership. Inside the membership, you'll get access to regular coaching on pricing and project management, among other things, so you can build a more efficient, profitable, and productive practice. Get on the waiting list, and you will be the first to know when we open it up again, and spoiler alert, there may be a Halloween special. If you'd like to get tips like this regularly, just sign up below. Thanks a lot, everybody. We'll see you next week.